Okay. Good afternoon. Welcome to the final and the championship round of the Spring 2025 Faegre Drinker Moot Court competition. It's great to be here. Thank you all for coming. This, as you know, because you all went through it, is a culmination of 2 weeks of competition. Sometimes this is more affectionately known as Baylor Law School's March Madness. And there was plenty of madness, was there not, over the last 2 weeks. So, but the championship round today is the result of 4 days of preliminary rounds in which we had 126 matches that you guys participated in. We had 30 single elimination rounds in the playoff rounds starting last week. And so our 2 teams that are here today are to be congratulated. They are Team 14 representing the Appellant. That's Bryce Babcock and Kyle Zeidema, right? Did I get that right? Yeah. And representing the Appellees are team number 85, Kelsey Crow and Caitlin Stevens. So let's congratulate them. I told them not to be intimidated by the fact that all their classmates are watching today and that it's being broadcast wherever in the world anybody wants to watch it on YouTube. Don't let that worry you. Just get up and be calm. Everything will be fine. We'll get started in a minute, but I do need to make some thank yous. And the first thank you that I need to give is for the sponsor firm, Faegre Drinker. This is the 7th year that that firm has sponsored this spring competition. It's been a tremendous partnership with them. They provide us financial support, but they also provide judging support. They sent judges down to judge in the playoff rounds, and sadly, the judge that was supposed to be with us here today called in sick this morning. He was sick and he's not able to come. So we're sorry about that, but we do thank the firm very much for their continued support on this. Other thank yous that I need to give, first of all, are the Baylor Law School staff and faculty. I started to sit down and make a list of everybody who needed to be thanked by name, and eventually it got so long that I think I'll tell y'all, just go to the Baylor Law website, look at the staff, and thank everybody on that list, because everybody played a little bit of a role in this, all right? And faculty as well. I mean, we have good faculty support with judging and whatnot. But this is a student competition. It's student run. You guys are the students, are the competitors. Students are the judges until we get into the playoff rounds, and students run the competition. And it's these folks sitting right over here who we owe a big thank you to because of all the work they put in. I want to recognize them each one. We call the barrister officers, the 2 students who are responsible for getting the barristers, 130 of them. Keeping them in tow is a big task. All right, and so the students who did that were Krista Walton and Elizabeth Carr. So is Krista here? The vice presidents, who do a little bit of everything, I think, mostly a lot of it I see that they're doing is crunching the numbers in the data as it comes in. And that's a pretty big task on a daily basis just to keep up with all the data. That's Noah Sullivan and Evan Goodman. And they are the vice presidents. They'll be back in the fall for additional fun. So, Noah and I want to especially thank Hannah Sewell and Allie Barnett, who've been the presidents this quarter. Last quarter they were vice presidents, so they put in a full year. This team was incredible. When you guys check in and check out, all you see is the very tip of the iceberg. They put in countless hours to make this whole thing work. And I think it went incredibly smoothly, and it's thanks to their work. So thank you. Okay, I can't get out of here without thanking the barristers. The barristers really stepped up and made this thing work. They volunteered to do extra rounds, and so that enabled us to increase the number of judges that you had in the last preliminary round to 2, and it makes a big difference the more judges you have. So I want to thank the barristers. Finally, I want to thank each and every one of you who acted as a competitor. You know, it's really nice. We set this up in a competition format, and that goes back decades, probably back in the very eons of time when Dean Counselor was a student here. So I think it's been set up as a competition for that length of time, and it's great. We want to celebrate that, and we want to congratulate these teams, and we want to have fun with it. But don't lose sight of the real purpose of this whole process, and it was for you to take your scholarship that you've learned in the classroom and actually put it into play as lawyers. You learn the process of lawyering. You get a difficult problem that you've got to figure out, how are we going to make the argument, and then you go in and make it. That's the real purpose of this. And so if you went through that, you accomplished that purpose. Some of you may be very disappointed that you're not sitting here. Some of you are probably very pleased that you're not sitting here. But don't lose sight of the fact that the purpose of it was to give you the opportunity to step out of the classroom and get the chance to argue a case. So that's all I've got. Did I forget anything? Okay. I'm going to take a seat in the judging slot, so I'll run up there and then we'll get started. Let me tell you, after this is over, the judges will retire back to the dean's conference room to deliberate. It'll take 15 or 20 minutes. We got a lot of refreshments out here, so help yourself to the refreshments. Do me a favor, don't mess up this room too much because we've got to clean it up after we're done. So clean up after yourself if you go out and get refreshments. Okay? All right. What do you mean, did I forget anything? I didn't forget anything. I've got to introduce the judges. See, I had my notes here as a safety net, and I ended up using them as a crutch. Right? Okay, let me introduce the judging panel. On the ends are the student winners from the fall, Kagan Baldry and Michael Rowley. The winners of this competition will go back and be the judges in the next competition. Okay? I want to introduce, we have two professors, Professor Steingraber and Professor Tang, who are teaching sections of the LARC 3 class. They're on the panel. We have a couple of visitors. The Chief Justice, or the Chief Judge, I should say, since we're in the Fifth Circuit, not the Supreme Court, is Jennifer Richards. Jennifer is a graduate of Baylor Law School. We spent time together in Cincinnati on a moot court competition years ago. Professor Underwood can tell you all about that trip as well. I won't do that right now, but thank you, Jennifer Richards, for being here. Also here is Tiffany Scraw. Tiffany is a moot court expert. That's what she does in her spare time because she says she doesn't have any other hobbies. She does moot court. Thank you guys for coming down today. I'm going to shut up and we'll get started. Okay.
We're hearing cause number 24-AABB. Appellants, please proceed when ready.
Chief Judge, Your Honors, may it please the court. My name is Kyle Zeidema. My co-counsel is Bryce Babcock, and together we represent the appellant, Ms. Bridget Jägermeyer. And this appeal presents two issues. I'll be addressing the first issue today, whether the district court properly disregarded deposition corrections made by a non-party deponent. My co-counsel will be addressing the second issue, whether the district court properly disregarded claims in Ms. Jägermeyer's summary judgment response. Before I begin with my arguments, with the court's permission, I would like to reserve 3 minutes for rebuttal.
Granted.
Thank you. Your Honors, the district court's decision effectively turned depositions into traps. By importing a judicially created doctrine when there is an explicit rule on point, the district court locked Dr. Edison into an honest mistake, and in doing so, denied Ms. Jägermeyer of the opportunity to seek just compensation.
Is yes when I really meant no an honest mistake?
Your Honor, under Supreme Court precedent, the facts at the summary judgment stage, in Anderson versus Liberty Lobby to be specific, cited on page 28 of the record, the facts at the summary judgment stage are to be construed in the light most favorable of the non-moving party. And so it is to be construed as an honest mistake, the mistake given in the deposition errata sheet change. Your Honors, the district court erred in its decision to grant Bateswood's motion for summary judgment for 3 reasons. First, as a matter of law, the district court erred by failing to apply the broad approach to Rule 30E and instead importing the sham affidavit rule. Second, as a matter of law, the district court erred by extending the sham affidavit rule to a non-party witness, something that multiple circuits have rejected. And third, the district court just plainly abused its discretion by the application of the sham affidavit rule under these specific circumstances, given the fact that there was no summary judgment motion on the table when Dr. Edison had made his corrections. Your Honors, the Federal Rules of Civil Procedure and Rule 30E explicitly state that a deponent may make any change in form or substance as long as the procedural requirements are met.
Counsel, has the court defined what form and substance means in these cases?
Your Honor, the majority of courts construe form to just mean transcription errors, basic transcription errors, and substance to actually mean changing facts, similar to like basically how Dr. Edison did in this case.
Are all the errors that Dr. Edison submitted on the deposition errata sheet purely all contradictory errors, or were some of them form or transcription errors?
Some of them were form and transcription errors, but the errors at issue today, or the corrections at issue today, are the corrections on pages 8 and 9 of the record, where Dr. Edison was asked about whether he had read the Modern Medicine article prior to prescribing Targetol, and whether he had known of the risks of the drug before prescribing it. Your Honors, the district court just ignored the plain meaning of the word substance in Rule 30E, and instead adopted a minority approach that just disregards that word substance. The Greenway Court, cited on page 13 of the record, is one of those minority courts, and decided to just limit the changes that can be made in a deposition errata sheet to transcription errors, just completely disregarding the plain language of the rule. And again, as I previously mentioned to Your Honor, the majority of courts have apply the rule and interpret it as it is, as under the plain meaning of the rule. And this rule
Aren't you disregarding a growing body of law from some circuits that do acknowledge that we should apply the sham affidavit rule? You're making it kind of sound like that area of law is not even there. Tell us about it.
That area of law is there. There are some circuits that, well, it is a minority to apply the narrow approach, but it is still there, and we recognize that.
And what's their rationale?
Their rationale is that it undermines summary judgment, but it actually undermines summary judgment to construe the rule narrowly. And going back to the Anderson court cited in page 28 of the record, at summary judgment, the facts are to be construed in the light most favorable to the non-moving party. This is a fundamental principle of our judicial system, and specifically the summary judgment stage. And a second principle that is just fundamental.
But wait, if we say that, then aren't we taking away the trial judge's discretion on what facts should be considered? For example, that's the whole reason we have a sham affidavit rule, so that parties can't just undercut and submit an affidavit that everyone knows is bogus. So if we take that discretion away from the trial court, are you saying that it shouldn't have any discretion to consider evidence because that would undercut the meaning for a summary judgment?
Your Honor, in the context of depositions, no, the district court should not have the discretion to apply the sham affidavit rule or apply the narrow approach. But especially in these circumstances, it's important to get this straight from the outset. There was no summary judgment motion on the table when Dr. Edison made his corrections. As noted on
Is
page...
an errata sheet a statement under oath made subject to penalty of perjury?
No, Your Honor. No, Your Honor. As the Rule 30E explicitly allows those deposition corrections.
But is it under oath?
Yes, Your Honor, it is under oath. It is a statement under oath. But just going back to that point
What
about...
happens when we have an errata sheet that changes substantive testimony? Do we view those as a merged document? Does the original testimony still exist? And now we still have the errata sheet, so we have this conflict. How do those two things interact?
That goes to one of the safeguards that's in place that the Lugtig court outlined and it's cited in page 26 of the record, that those original answers remain in the record throughout the course of the litigation so that the jury can be the determiners of credibility, not the judge.
What would have happened in this case if the trial judge had kept the two to allow the fact finder to reconcile it, rather than just throwing out the errata sheet?
Then the fact finder would be the ones to determine whether Dr. Edison is credible or not. And so the jury would have its role of determining Dr. Edison's
Counsel, but
credibility.
wouldn't that allow people to avoid summary judgment just by creating some false fact issue?
Your Honor, yeah, that brings a good point. That goes back to something that I was mentioning before. Here, there was no summary judgment motion on the table when Dr. Edison made his corrections.
Right, but it was in a proper time for them to file this summary judgment motion when they did, correct?
Yes, the opposing party could have filed a summary judgment motion and didn't. But that's important because Dr. Edison wasn't able to see their summary judgment motion. And this is completely unsupported by precedent to apply the sham affidavit rule before there's a summary judgment motion on the table. This rule applies when a party can see a summary judgment motion and then submit an affidavit that completely contradicts what they previously said to dodge summary judgment. But that's not what happened here, and no precedent supports the application of the rule under these circumstances.
Counselor, should there be no safeguards at this stage? I mean, because we are now allowing this change to be made. The sham affidavit rule serves one purpose, to safeguard facts.
Mm-hmm.
Is there anything left if you're advocating for that rule to not be applied here?
Yes, Your Honor. I mentioned one safeguard when I was speaking to the other judge. The safeguard of allowing the answers to remain in the record for impeachment at trial. There's a second safeguard that courts apply, and that's to reopen the deposition at the cost of the party who summary judgment is being sought against.
Well, but correct me if I'm wrong, but the panel who issued the original opinion in this case didn't reject the broad approach. In fact, I think it said the broad approach works fine. We just want to carve out this exception for the sham affidavit rule. Am I right about what the decision by our panel was?
Based on the facts, it seemed that the panel was applying the narrow approach and applying the sham affidavit rule to the errata sheet under these circumstances.
Okay, well, so let me clarify this. Are you arguing that we should not adopt the sham affidavit rule altogether? Or are you okay with us adopting that and just saying it doesn't really apply in this case?
Yeah, to be clear, we are asking the court to apply the broad approach to Rule 30E, and every jurisdiction applies the sham affidavit rule, but in its specific context. When there's a summary judgment motion on the table, and then a party submits a contradictory affidavit afterwards. But an important thing to note is that the sham affidavit rule is a judicially created doctrine where there's no rule on point. So it fills
would you be okay if we applied the sham affidavit rule if the doctor had made his changes after the summary judgment had been filed? Would it be a different case then?
Yes, Your Honor, that would be a different case. But it's also important to note that the application of the sham affidavit rule to a third party is also inappropriate and something that multiple circuits have rejected.
Do they draw the line at non-party versus party or interested versus uninterested? Because you can see that there are sometimes non-parties that are a lot more interested in a case than others.
Yes, Your Honor. The three courts that have rejected the approach of applying to a third party have just made the point of the distinction between a party and a non-party. In the Ninth Circuit in Nelson versus City of Davis, cited on page 28 of the record, points out that non-parties generally just don't have the same incentive to manipulate testimony as litigants do. And that is precisely what we can see with a reasonable reading of the facts here. It's important to remember that Ms. Jägermeyer and Dr. Edison's relationship is adversary. As noted on page 7 of the record, either Ms. Jägermeyer was going to sue or did sue Dr. Edison and had to settle their claims. It wouldn't make sense for Dr. Edison to perjure himself to get Ms. Jägermeyer out of summary judgment, the person that sued him. And
Aren't we asking our district courts to undertake what's a very onerous test and what should be a relatively straightforward Rule 56 analysis? Because what it sounds like you're saying is that now we have to look at who executes the errata sheet, when was it executed, did they have this incentive for perjury, and that all sounds like the type of fact-finding that we're not really supposed to conduct in the summary judgment stage.
that's a great point, Your Honor, which is why we are suggesting that the court does not apply it to errata sheets to begin with, that the court does not apply the sham affidavit rule to errata sheets, because then we need to start going into this role of fact-finding that should be reserved for the jury, as the Anderson court emphasized in Anderson versus Liberty Lobby.
Counsel, you said something at the very beginning of your argument, and you said that this turns depositions into traps, but isn't that just kind of part of litigation? And if a litigant decides to turn deposition into a trap to try to search for the truth for a witness that might not be the most honest, aren't they allowed to do that?
Well, Your Honor, I like what you said with the word truth, because that's actually the whole point in a deposition, is to find the truth. It's not designed to be a trap. It's designed to find the truth so that the case can be decided on its merits, not so that somebody can get trapped into something that results in an unfair granting of motion for summary judgment. And, Your Honors, I just want to reiterate that depositions are not traps. We urge this court to not apply the sham affidavit rule to depositions and to not go further by extending it to non-party witnesses. For these reasons, we ask that this court reverses and remands for further proceedings. Thank you.
May it proceed, Your Honor?
You may.
Thank you. Chief Judge, and may it please the court. I'm Bryce Babcock, counsel for the appellant, Ms. Bridget Jägermeyer. I'll be addressing the second issue regarding the trial court's abuse of discretion in denying Ms. Jägermeyer leave to amend her complaint in her summary judgment response. Your Honors, as does the first issue, this issue hinges on the application of a judicially created doctrine where it wasn't meant to apply, exalting form over substance and kicking out possibly meritorious claims. This court should reject the approach that says the difference between a meritorious claim and a disposable one relies solely on a caption in a motion paper. This court should reverse and remand for further proceedings with instructions to allow Ms. Jägermeyer to leave to amend her complaint for 3 reasons. First, the federal rules of civil procedure, by their terms, do not expressly prohibit a plaintiff from amending her complaint in a summary judgment response. Second, the policy reasons behind that blanket prohibition on amending a complaint in a summary judgment response are inapplicable as applied to Ms. Jägermeyer's case. And third, the district court abused its discretion in denying leave for Ms. Jägermeyer to amend because there was no harm to the defendant. On to my first points, Your Honor.
Where do the rules say that Ms. Jägermeyer can seek leave to amend in a motion for summary judgment response?
So it's a good question, and it goes to my first point. So in Eminence Capital LLC versus Aspen, cited on page 34 of the record, the court in that case stated that absent prejudice or a showing of the Foreman factors, there exists a presumption under Rule 15 in favor of granting a motion to amend because of that express language that the court shall grant leave when justice so requires. That's the only limiting factor in Rule 15 on when a court can grant leave.
I think the key, though, you just said is motion to amend. Where is the motion?
The motion we're arguing is a de facto or a constructive motion, that the trial court should have treated our response with new claims in summary judgment as the motion to amend, especially because courts have considered this issue prior and stated that a formal motion is not always required, that it provided that there is something substantive that the plaintiff is bringing that show they have new claims to plead, that will suffice.
So are we requiring courts to read litigants' minds?
No, Your Honor, we're not requiring courts to read litigants' minds. There still must be some particularity in what the plaintiff actually pleads. And we would note that Ms. Jägermeyer did plead essentially new claims, or at least pled them enough with enough evidence that the trial court should have considered them as at least a motion to amend. It also would have been completely appropriate for the trial court to say, okay, looks like you're raising new claims here. I'm not sure if you even know you need to bring a motion to amend, which is something that the Schmies court, which considered this issue recently, also considered, that plaintiffs may not even always know they need to bring a motion to amend. And so it would have been completely appropriate for the trial court to say, look, bring a formal motion so you can tell me what claims you're actually bringing here, because it looks like you're bringing new claims.
Isn't it antithetical to our adversary system for courts to tell people how to do their jobs?
No, Your Honors. The courts have broad discretion, and they should have discretion to be able to instruct plaintiffs. That's actually what the court did in this case, earlier in the case, is instructed the plaintiff on how to particularly plead her claims. Now, of course, Ms. Jägermeyer might not have had enough evidence at that time to be able to bring these claims. But courts do have the discretion to be able to instruct a plaintiff, hey, I would like you to bring a motion, otherwise I'm going to grant this summary judgment motion.
They may have that discretion, but is that something we want to make as a matter of routine practice?
No, Your Honor, we're not arguing for a routine rule. We understand that this situation is the exception rather than the rule. The Schmies court, once again, which took up this issue in the Seventh Circuit recently, stated that this is an improbable confluence of events. However, this case meets that improbable confluence. So it's completely fine for courts generally to construe the facts that a plaintiff brought a claim in a summary judgment response against them. But when the rest of the Foman factors go our way, a court shouldn't simply kick us out, as I stated, simply because we didn't caption our motion paper. That's not doing justice when it so requires. And that really leads to my second point, Your Honors, which is that the policy reasons behind a blanket prohibition, which a majority of courts, as the appellees will certainly state and the initial ruling of this court did state.
Before you move on, you said the phrase motion paper a few times. Doesn't Rule 7 require a motion paper?
Once again, I would point to courts which have found that there doesn't need to be a particular motion paper. As long as the plaintiff is bringing new claims or at least raising new claims, the federal rules are liberal and should be liberal. They allow plaintiffs a leave to amend when justice so requires.
Doesn't Rule 7 require a motion paper, though?
Yes, Rule 7 does require a motion paper.
Why is this case special? You said it's an exception. What makes it an exception?
That's a great question, Your Honor, and that leads to my third point, actually, which is the Foman factors. So we don't actually have to wonder about when the justice so requires. The Supreme Court has given us a test, our 5-part Foman test, that when there's undue delay, bad faith or dilatory motive, potential prejudice, futility of the amendment, or inability to cure prior deficiencies, that justice doesn't require that you allow a plaintiff to amend their complaint.
But isn't that the analysis that our judges go through when there is a pending motion before them? What are we going to do to flag to our poor district judges that every motion that comes across their desk, they need to run an analysis and determine if it's actually a motion for leave to amend in disguise?
So we think the same analysis should apply in either a de facto motion or an actual motion, a caption motion. The fact is that we already have this analysis, and it works pretty well. And so when the Foman factors go our way, as they do in this case, then the court should construe that as a motion for leave to amend and grant that motion. Or at least
I have the same question as my colleague, which is what flags to the judge that they need to run that analysis? Because wouldn't that be the attorney's job? So is it at the oral argument, if there is oral argument, which in federal court there often isn't? At what point is that flagged for the judge?
It could be. When it's flagged is when the plaintiff is bringing new claims that require a new set of elements to prove. And that's what happened in this case. So our plaintiff brought new claims that weren't related to the original claims. So the original claim was a failure to warn physicians claim, and this claim is now that we're talking about are two, which is a failure to warn patients, as well as a design defect claim. And so when the judge can look at the claim and make that determination of these are new legal claims that require new elements to prove, then we might have to go through this analysis of a Foman analysis and say, well, is it proper for a plaintiff to be allowed to amend their complaint at this stage? And that's really what sets our case apart.
So you just said that the attorney may not have known that he needed to file a motion to amend because he wouldn't have recognized the new claim, but we expect the judge to recognize the new claim. Shouldn't that be the attorney's responsibility as he's managing his case?
So the Schmies court actually expressly directly addressed that issue, and they said that the judge is generally in a better position just because the the fine distinction between legal theories and new claims which require new elements or new proof, that a plaintiff may think they're pleading a legal theory when actually they're pleading a new claim. It's worth noting that we did concede these were new claims. However, that doesn't necessarily mean that when the trial attorney filed her motion in response to summary judgment that she knew at the time that they were new claims. And so what really sets our case apart, going back to Your Honor's question, is the stage of the process at which this happened. So trial courts have generally, when appellate courts have generally taken up this issue, there's generally a foment factor that goes the way of the defendants. There's some evidence of bad faith. There's some evidence of undue delay, because this happens so late in the litigation process, because summary judgment is usually filed later. We would note the timeline of events here. So we filed this case in April of 2022. The drama around summary judgment happened in November, December of 2022. However, the trial date wasn't set till January of 2024. And so generally the reason that the courts construe this blanket prohibition is because defendants may not have time to conduct discovery such that they don't have proper notice and they'll be prejudiced in defending this case on the merits.
So are
When
you
was the
saying,
deadline for leave to amend?
The deadline for leave to amend was set in August of 2023. Once again, this stuff happened in December of 2022. And so the defendant would have had plenty of time to conduct discovery on this case. And
But there was no need for that. I mean, put yourself in the defendant's shoes. They answer a lawsuit that says they file a 12B6 motion because you haven't stated a plausible claim. The judge says, you're right, I agree with that. Refile your pleading and plead the claims that you're going to assert based upon the statute, the law that's in play. And so you guys plead a single claim that the labeling was defective because it didn't contain an adequate warning to doctors. And so Bateswood gets the evidence that they think negates that, and they move for summary judgment. Why should they? It seems like you're allowing, how many opportunities does your client have to have after express instruction by the judge to make Bateswood even think that it needs to do additional discovery?
so that's a great question, Your Honor. And it goes to why the plaintiff didn't bring these claims earlier. So I would note two reasons. Even if that was a misstep, in Conley versus Gibson, the Supreme Court stated that a simple misstep by counsel is not the purpose of pleading. The purpose of pleading is to facilitate trying the case on the merits.
This seems like more than a simple misstep. It was contrary to an express instruction by the judge.
That really goes to my second answer to your question, which is that just because the judge states that we need to bring all claims doesn't necessarily mean we have the evidence to be able to support those claims.
But you had an affidavit in hand that if I were the lawyer handling the case, I would have been comfortable asserting those claims based upon that affidavit. What additional discovery was needed?
The additional discovery perhaps was just that the plaintiff's attorney felt that the affidavit wasn't sufficient in order to meet the Iqbal and Twombly standards of a plausible claim for relief.
but they thought it was sufficient to create a genuine issue of material fact in response to a motion for summary judgment?
Well, no, we're not trying to create a genuine issue of material fact with
Then why does it
that
matter
claim.
if the amendment wasn't denied or not? Or if the amendment was allowed or not?
I apologize, can you repeat that?
We're talking about the affidavit. So if we're looking at this affidavit and before it wasn't good enough, but now when we're responding to a motion for summary judgment, it is, how do you square that?
Well, because of the different context. So Your Honor's question was about whether or not we should have brought a motion prior. Whether we should have amended our pleadings prior. This is simply a motion to amend a pleading. So we don't have that same Twombly standard of plausibility pleading. We just have to show that we have a claim that if we were allowed to bring a motion, we might have made a plausible claim. And so the attorney might have thought, well, I don't have enough now. I'm going to conduct additional discovery on these claims such that I can bring a claim that meets that plausibility pleading standard, especially since these were design defect claims, which the Bryant versus Hoffman-LaRoche case cited on page 36 of the record notes that the restatement of torts on this area is particularly difficult law. And so the court, or the plaintiff's attorney understandably could have said, look, I need more to conduct more discovery on these claims to be able to understand whether or not I have a valid claim, which is what she cited in the record for why she didn't bring those claims earlier.
So if I understand you correctly, then it's your position that the evidence offered in the summary judgment response was not sufficient to create a genuine issue of material fact on these new claims?
No, Your Honor. What our position is that the plaintiff's attorney may have wanted to ensure that they had enough evidence in order to bring those claims in a plausible claim for relief. So not that the affidavit in it itself wasn't enough, but that the plaintiff may have construed it as not enough. And once again, even if that was a mistake, that's something that the court could construe against us. And we think because the rest of the foment factors, because the defendant would have had time, because we brought this so early on in the case to conduct discovery on this case, that the defendant wouldn't have been harmed in pleading this case or defending this case.
But wouldn't that have incurred a lot more money and expenses and attorney's fees in order to conduct that extra discovery? I mean, why should we allow litigants to, delay and fish for more claims?
So if I may briefly conclude, Your Honor, I'm out of time. It's a good question. Pasternak versus Schrader, case from the Second Circuit in 2017, actually directly addressed that and said that delay without more and litigation expense without more is not sufficient to deny a motion to amend a pleading. Simply because that would always be true. There's always going to be additional litigation expense anytime a plaintiff moves to amend their complaint, and so that shouldn't be any different here. For the foregoing reasons, this court should reverse and remand with instructions to allow Ms. Jägermeyer leave to amend. Thank you.
May I proceed?
You may.
Thank you. Chief Judge, Your Honors, and may it please the court. My name is Caitlin Stevens, and along with my co-counsel, Kelsey Crow, we represent Appellee Bateswood Healthcare Products. As my opposing counsel mentioned, there are two issues presented here on appeal. First, I will address why the district court properly disregarded the changes to the deposition. Second, Ms. Crow, my co-counsel, will address why the district court properly denied Jägermeyer's attempt to amend her pleadings and her response to Bateswood's motion for summary judgment. Your Honors, this case is an opportunity to uphold the integrity of our justice system and empower district courts with the tools to promote fairness and efficiency. We ask that this court affirm the district court's decision and hold that it was within its discretion to disregard the contradictory material changes to the deposition through the errata sheet. We ask that this court affirm for the following two reasons. Public policy and the language of Rule 30E gives courts the discretion to decide how they may deal with deposition changes. Second, the court did not abuse its discretion because errata sheets that make contradictory material changes in the context of a summary judgment are akin to sham affidavits and should be disregarded. Going to my first point.
Does your first point contradict itself? We're saying that we need to follow the rule, but then you're saying that public policy dictates that they have to have discretion. So if we're going to use our discretion, aren't we necessarily going outside of applying the rule?
Your Honor, the plain language of the rule does not prescribe any restrictions on how a judge may examine the sufficiency of the reasons, nor does it prescribe how judges may deal with the reasons. As my opposing counsel mentioned, it sets forth
Doesn't that mean they just have to take the reasons, not that they get to assess their validity?
Your Honor, in support of the public policy and the purpose of the federal rules of civil procedure to allow or to restrict a court to blindly accept any changes despite the circumstances would undermine swearing under oath, our summary judgment process, and would overall undermine the district court's ability to promote fairness and efficiency within their courts.
Well, to the appellant's point, don't you just get to take the good doctor on cross-examination?
Your Honor, to simply wait until cross-examination or trial to impeach this witness would prolong the court's time, resources, and makes less sense when we can disregard these changes now under the sham affidavit doctrine, which has a deep, valid, entrenched role in our jurisprudence. But going back to that first point, that the language in the context of the purpose of the federal rules of civil procedure should not require a judge to blindly accept contradictory changes.
The court said that the reasons for changing were, quote, unconvincing, I think is what the lower court said. So what would be convincing? If we're going to write in language to the rule that's not there, for example, for a sham affidavit, we know that we've got a bad faith standard, but that's not in Rule 30. So what makes it unconvincing?
The Third Circuit in EBC, the court applied the sham affidavit analysis and said that the reasons given were not convincing because they were conclusory and not supported by corroborative evidence in the record. For example, if Dr. Edison had realized after being deposed that he was on vacation 2 years prior in the Bahamas, and there's no way he could have received that Modern Medicine article. Or he was transferring doctor's offices, and he had an address change, and there was no way he could have received that article. And upon thinking about it, he realized that and provided those changes and that reason. That would be a non-conclusory reason supported by corroborative evidence that the court, under the sham affidavit analysis, could accept.
Doesn't this run the risk of judges becoming a fact finder on credibility? Isn't that specifically foreclosed in a motion for summary judgment?
Your Honor, we acknowledge the concern with making a credibility determination. However, in this case, and applying the sham affidavit factors do not require a party or a judge, to make a credibility determination. Again, we do concede there have been courts who have noted in applying the sham affidavit rule with care. However, those same courts have made a distinction in where changes are so unambiguously contradictory that the application of the sham affidavit analysis is warranted, and a line can be drawn between the two.
I understand that it doesn't necessarily require a credibility determination, but it does seem a little bit like in this case there was a bit of a credibility determination, because specifically the court said that it was unconvincing. I mean, is it really the job of the litigant to convince the judge that their reason is good enough?
Your Honor, we would respectfully disagree that the court did make a credibility determination here, applying these factors, given how contradictory his answers were, and I'll address those factors in just a moment. But also, assuming they did have the discretion to apply this rule, we are viewing this court's decision in a abuse of discretion standard and would only reverse if the outcome was illogical, implausible, and not supported by inference of the record. And once we go into these sham affidavit factors, that is not the case. It is plausible and logical that reasonable minds could not differ that his changes were a sham.
Could you respond to your opposing counsel's point about the timing of his changes? He made the changes apparently before a summary judgment was ever filed.
Yeah.
How do you respond to that?
Yes, Your Honor. The fact that the motion for summary judgment had not been filed is irrelevant, and it would be arbitrary to draw a line in determining on whether or not to apply that rule. Glenwood Farms, Inc. v. Ivy, a district court in Maine, on ruling for a motion to strike, said that the party could later at the motion for summary judgment stage apply the sham affidavit analysis if the party relied on those contradictory changes to prevail at the motion for summary judgment. Furthermore, TXU versus...
So the timing of the motion doesn't matter. You said that. You said it's irrelevant.
Yes, Your Honor. The incentive to create a sham issue of fact does not go away simply because a motion for summary judgment had already been filed. A party a prudent lawyer is likely to want to prevail at the motion for summary judgment stage.
I'm concerned that this whole thing just sounds like a classic fact issue, that we ought to just throw it to the jury and say the doctor one time said yes, now he says no, y'all figure it out.
Your Honor, given the precedent in this sham affidavit policy, which goes to my second point, to require a court to always allow contradictory changes to go to the jury would undermine the efficiency and the purpose of the motion for summary judgment process. In Jackson versus Teamster, they pointed out that it would not make sense to prohibit a contradictory affidavit but allow a contradictory errata sheet, as this would provide an effective workaround of the sham affidavit and undermine our summary judgment process.
So go through this hypothetical with me. Let's just say that the judge had denied summary judgment for a different reason. So it didn't get to this issue or didn't throw it out. Are you saying that now, if it goes to trial, that the litigants get to present both the original deposition and the errata?
Your Honor, with our motion to disregard in conjunction with the motion for summary judgment, if I may clarify with your hypothetical, would we have still filed the motion to disregard in this context?
No, I think my question is a little different. Let's say that everybody missed this issue and the judge denies summary judgment. You get to trial. Are you going to object to the other party using the errata sheet and say, Judge, that's hearsay because it's a sham? Or can the judge then use it in trial and let the jury have both the original deposition transcript and the errata?
Your Honor, if a party declines to disregard the changes before going to trial and doesn't pick up on that issue, that is a responsibility of the counsel to pick up on that issue, and it's not the responsibility of a judge to disregard those changes automatically, as we're not arguing for the narrow approach. If that were the case, Your Honor, counsel would likely have the chance to impeach the witness, and then would negate any issue of material fact, which would dispose of the case then and there. And then going,
Why is the date of filing this motion for summary judgment arbitrary, as you said before? It seems that would lock in whatever facts are in the deposition, but if that change was sought to be made before, then that seems like a pretty fair line for considering the matter that would be present at the motion. It seems like a good date to consider.
Your Honor, sorry if I misspoke. When I said it was arbitrary, I meant it was arbitrary in deciding on whether or not to apply the sham affidavit analysis, because a party still has incentive to create a sham issue of fact, despite the fact that a motion for summary judgment had not been filed. Going back to my
What is the sham affidavit analysis that you're asking us to adopt here?
The sham affidavit analysis looks at the following 3 factors to determine whether or not the changes are considered a sham. First, whether the witness was cross-examined. Second, whether the witness had access to pertinent information at the time of testimony, and whether their changes reflect newly discovered evidence. And then third, whether the earlier testimony reflects confusion that the deposition changes attempts to clarify.
But counsel, don't 2 of those factors seem to cut against you, those latter 2? It seems like it was very clear at the time in the doctor, when he was making his changes to his testimony, doesn't seem to indicate there's any kind of confusion, and there's no kind of newly discovered evidence. Why do these factors seem to play in your favor then?
Your Honor, when the changes do not reflect newly discovered evidence or confusion, they actually point in favor of a sham. As the Burns and the Thorns court applied these factors, that would in fact weigh in favor of a sham, Your Honor. Going to that first one, whether the witness was cross-examined, on page 8 and 9 of the record, it reflects that Jägermeyer's counsel did follow up on questions. They had an opportunity to ask Dr. Edison many questions. However, did not follow up after he made this damaging testimony. And while they could and should have, Bateswood should not be punished for the lack of prudent lawyering on the behalf of Jägermeyer's counsel. Going to that second factor, whether the witness had access to pertinent information, we clearly asked him direct questions. He was likely woodshedded, as most deponents are before a deposition process. As a deponent,
Was he represented by counsel, or is that in the record?
yes, Your Honor, I believe it's on page 6.
He was represented by plaintiff's counsel?
No, he was not represented by plaintiff's counsel, but he was a witness for Jägermeyer.
Did an attorney present him for his deposition, or was he just there as a non-party by himself?
He was there as a non-party, as he had already settled. However, this would bring me into another point in that the sham affidavit analysis should be applied regardless of whether or not he is a third party. But if I may continue on those factors before I get into that, his changes did not reflect newly discovered evidence, nor did they reflect any confusion. He clearly answered that he had, yes, read the articles. There is no indication of confusion, and the factors do point.
Do nerves play into this analysis at all? I mean, I understand that maybe there wasn't an indication of confusion, but I mean, isn't it okay to understand that a witness might be nervous during their deposition and might not fully comprehend what they're saying?
Yes, Your Honor, we understand that a deposition can be scary and nerve-wracking. However, to require courts to accept those contradictory changes without an adequate safeguard in place would send us down a slippery slope where parties will abuse the rule and create sham issues of fact under Rule 30E.
Well, counsel, your opposing counsel already indicated there's 2 potential safeguards, reopening the deposition or allowing the original testimony to stand. Aren't those sufficient to protect against the concerns that you're articulating?
Allowing the testimony to stand at trial is not an adequate safeguard to prevent the integrity of the motion for summary judgment process, as is the stage we are at here. And then as far as opening the deposition, this would be inefficient and allow a waste of time and resources. It's also worth noting that in the 10 amendments since 1937, when the Federal Rules of Civil Procedure created Rule 30E, all of those amendments have been geared towards procedural requirements and increasing the efficiency of the deposition. If we are to open up every single deposition for making contradictory changes, we would undermine that efficiency and those procedural amendments created to create that efficiency.
Can you address the concern about the non-party witness? I mean,
Yes.
why doesn't that make a difference?
Yes, Your Honor. As Chief Judge pointed out, the heart of the distinction is really whether a party is interested or disinterested. In Ralston Smith v. Nephews Richards, Inc., the 10th Circuit applied the sham affidavit analysis to a non-party witness, and the facts are similar to that here. A plaintiff filed a failure to warn claim. Her physician made a testimony that negated any issue of fact, then proceeded to file a contradictory affidavit. The court applied the analysis despite the fact that he was a non-party witness. In the 8th Circuit, in Garnett Grainco versus Blackwell, the court said that it would make little difference to apply it to a non-party but not the other, especially considering here that Dr. Edison has a reputational stake in this claim. He made a damaging testimony that he prescribed his patient with a harmful medicine after reading an article about those harms. While it's fair that he doesn't want his reputation harmed, Bateswood should not have to pay to fix that reputation. Furthermore, although not a familial member of Jägermeyer, he is her physician and likely wants to see her made whole. However, again, Bateswood should not pay for his mistake in prescribing her the medicine. In the spirit of fairness, the pursuit of truth, and upholding the integrity of swearing under oath and motion for summary judgment processes, we ask that this court affirm. Thank you.
Your Honors, may it please the court. My name is Kelsey Crow, co-counsel for the Appellee Bateswood Healthcare Products. I will be continuing arguments on behalf of Bateswood regarding the second issue, that the district court correctly denied Ms. Jägermeyer's attempts to amend in her response to the motion for summary judgment. This case is about being fair to defendants who follow the rules and upholding judicial processes. Today we are asking that the court affirm the motion for summary judgment and find for Bateswood for 3 reasons. First, even circuits that allow constructive amendments at the summary judgment stage have recognized that those amendments are rarely, if ever, granted. Second, the amendment was appropriately denied due to the presence of several foment factors. And third, granting the amendment would have gone against public policy concerns of fairness and efficiency. Even if the court in this case had the discretion to consider the constructive amendment at the summary judgment stage, the court did not abuse its discretion in denying the amendment. See, even courts that allow these kinds of constructive amendments have recognized that they're rarely actually granted. The Schmees Court, for example, referenced by my opposing counsel, did say that these amendments are allowed, but as my opposing counsel mentioned, they're only granted upon an improbable confluence of events that is all but impossible for a plaintiff to establish.
So you agree that Rule 15A2 allows constructive amendments as a general matter? Or constructive motions for leave to amend?
We are just fine with a rule saying that these district courts have the discretion to hear these amendments, Your Honor, and that's because even if the court is allowed to hear those amendments, it did not abuse its discretion in denying this amendment. The Schmees Court, for example, also took this approach where they said that the courts are allowed to consider these amendments, but in Schmees, the plaintiff was denied the opportunity to amend, and the summary judgment was upheld.
So give us an opportunity or an example of when it should be granted.
Your Honor, for starters, we would need none of the foment factors present, which leads me right into my second point, that the court's discretion was not abused here because we did have foment factors present. Those factors, as previously mentioned by my opposing counsel, are undue delay, bad faith or dilatory motive, prejudice to the opposing party, and repeated failure to cure deficiencies.
What's our evidence of bad faith?
Bad faith, Your Honor, is the fact that, as Your Honors mentioned earlier, Ms. Jägermeyer had this affidavit of Dr. Loftus in hand back in April 2022 when she filed suit. Further, according to page 9 of the record, the court actually instructed Ms. Jägermeyer on how to amend whenever she was making her first amended complaint. At that time, Ms. Jägermeyer had all the evidence she needed to assert all 3 claims. Contrary to what my opposing counsel said about Ms. Jägermeyer needing more time for discovery, page 10 of the record reflects that she conducted no additional discovery.
Would you say that a bad choice is the same thing as bad faith?
Not necessarily, Your Honor, but here this was more than a bad choice.
What is our standard for bad faith? What does the court say about that?
Bad faith, Your Honor, in this case, Foman references a dilatory motive in that factor. So we're talking about a situation where a plaintiff is doing something to really delay the resolution of the dispute. They're doing something not because there is actually a material issue that the court might need to address, but because they want to put off the resolution of the dispute or give themselves more time in some way. But those Foman factors, another one that is met today is the repeated failure to cure deficiencies. See, Ms. Jägermeyer, she's already had 2 prior opportunities to plead her claims.
Haven't y'all defended against these same claims before from 2 other plaintiffs?
Yes, Your Honor, Bateswood is involved or has been involved in other litigation regarding Target All. This kind of brings us to the prejudice element of Foman. Just because Bateswood has faced other cases with Target All and similar claims does not mean that Bateswood should have fully expected to see those claims here. In fact, when Ms. Jägermeyer chose to plead only one of the 3 claims that the court presented to her as options to plead, she was affirmatively telling Bateswood, giving notice to Bateswood that she wouldn't be pursuing those 2 other claims. So when she turned around then after a motion for summary judgment and said, actually I am going to pursue those 2 claims, that's surprising to Bateswood.
Was the motion, or were they able to amend their petition at that point though?
At which point, Your Honor?
When the motion for summary judgment was filed, had the motion or the deadline to amend, had that passed?
The deadline to amend had not passed at that point, Your Honor, but we know that there actually can be undue delay despite the fact that the deadline hasn't passed. In Nielsen v. Kruger, the court there had a situation where a plaintiff waited to amend their complaint, and the court said that it was still undue delay despite the fact that that amendment deadline hadn't passed.
I think I'm more concerned with the surprise aspect, because how surprising can it be if they faced other cases, similar cases using these claims, and the plaintiff still had an opportunity to amend until they filed their motion? Is it really that surprising that they would have more claims in their back pocket, perhaps?
Your Honor, it is surprising to Bateswood because Ms. Jägermeyer had indicated that she was not pursuing those claims.
But would the evidence be different? Because they've been facing these claims from other claimants. Would the evidence to defend against Ms. Jägermeyer's claims be different from those other claimants?
Your Honor, this is a completely separate case. So we have a different plaintiff who took this medication perhaps at a different time. We have different timelines for both facts and things like discovery. So this is a completely different claim.
But this seems like the issues are common. If it's a design defect, that's not unique to your plaintiff. If it is that the company should have taken on the obligation to directly warn plaintiffs, there's nothing about that that's particular to your claim, is there?
In this case, Your Honor, again, as you mentioned, those are very similar issues, but we have to remember that prejudice is defined by, yes, undue surprise, but courts such as Pasternak, for example, have said that there is prejudice where there is undue delay to the resolution of the dispute, which we certainly have here, or additional expenditure that the other party must suffer because of the delay or because of this amendment.
What makes
Here,
delay undue?
the undue delay, that's one of the Foman factors and a measure of prejudice under Pasternak. Undue delay is when the opposing party, the one trying to delay or trying to get more time, is doing so in a way that is not, par for the course. That they're doing so just to get more time. That kind of goes into the dilatory motive. Here it is undue delay because Ms. Jägermeyer, again, had everything she needed to assert those claims and yet sat on that for about 8 or 9 months until she decided to amend, only when prompted by Bateswood's summary judgment.
If she had filed motion for leave to amend in advance of your client filing the motion for summary judgment, under the Foman factors, should the court have granted it?
If we were at the point, Your Honor, where you said Bateswood had not filed for summary judgment?
Correct. Same point in the case, discovery hasn't closed, the deadline for leave to amend hasn't passed, but she's been sitting on this affidavit for 8 months, and the court's given her two times for leave to amend, and she did not include it, and then files for motion for leave to amend. Under the Foman factors, should the court grant that?
The court would certainly have discretion to not allow that amendment, Your Honor. The court would be able to point to Foman factors such as perhaps undue delay, depending on what our timeline looks like, and repeated failures to cure deficiencies.
But do you think it would be within its discretion, without a motion for summary judgment pending, to grant the leave to amend?
The court, again, that's up to the court's discretion, but the Foman factors lead
in your opinion, though, would they abuse their discretion by granting it?
That could be abuse of discretion, Your Honor. Yes, if those foment factors are present, we know that the court should not grant that motion to amend. But here, the summary judgment is particularly important because we're looking at the fact that Ms. Jägermeyer is raising these claims only just in time, coincidentally, to survive a motion for summary judgment. So she only brought them up in response to keep herself in the game. Perhaps she saw the first claim wouldn't work out, but she brought these two new claims as a dilatory tactic purely to push off the resolution of this dispute, Your Honors. In doing so,
But y'all moved for summary judgment pretty quickly. What's the harm in pushing things out another 6 months if it means that the district court can fully air these two new claims that you've defended in 2 other cases?
Your Honor, Bateswood was perfectly within its right to move for summary judgment as soon as the evidence developed to do so. There is no rule saying that summary judgment must wait until every deadline for pleadings or discovery or something like that is passed. So Bateswood was well within its rights to move that quickly.
Yeah, but by choosing to be aggressive, it left itself open to the fact that the deadline to amend was still open and that discovery was still open. So how does that cut against your foment factors? For example, the, what's the one, prejudice?
Yes, Your Honor, we would respectfully disagree that Bateswood was moving aggressively. Again, the evidence had developed, so Bateswood moved for summary judgment, something that every defendant is well within its rights to do.
But then once the evidence had developed and then changed, why don't we just kick things out 6 months and let the district court decide everything? I'm not seeing the harm to
Yes,
your
Your Honor,
client.
the evidence actually had not developed and changed. See, we're talking about something that Ms. Jägermeyer had in hand before filing suit. And contrary to what my opposing counsel said, this is not a case where a plaintiff simply didn't know they needed to amend. She'd amended before. She knew how that worked. So this wasn't a case of just, oh, well, let's let them be heard because she didn't have a shot. She had multiple shots. And plaintiffs bear the burden of their own pleadings. If Ms. Jägermeyer was truly so concerned about her failure to warn patients and defective product manufacturing claims being heard and put before a court, then she should have originally pled them or added them to her first amended complaint as the court instructed her to. In fact, courts such as Salamea v. Tarsidia Hotel in the Ninth Circuit said that when a plaintiff fails to follow a court's specific instructions on how to amend, the court can deny that amendment. So Ms. Jägermeyer did not follow the court's instructions. She did unduly surprise Bateswood with her actions in this way, because they were entitled to rely on her pleadings as an indication of what they were going to be up against. And we think that these kinds of behaviors by plaintiffs are actually pretty unfair, which brings me to my third point, that granting the amendment would have gone against public policy concerns of fairness and efficiency. By granting the amendment today, Your Honors, we'd be setting a precedent, telling defendants that they cannot rely on the pleadings of plaintiffs as indications of what they're up against. We're on a slippery slope. We'd be telling plaintiffs it's okay to keep a claim up your sleeve, to bring out just at the last second.
Well, that's why we have deadlines for leave to amend and can amend. What do you say to your opposing counsel's argument that just additional expense and time is not a factor to be considered? Because it sounds like that's what you're arguing, that it's causing your client additional time and expense.
So actually, we know that undue delay can be grounds alone for denial. We learned that in Hayes v. New England Millwork Distributors. The court said, and I quote, "Undue delay can be a basis for denial." So that alone is perfectly sufficient. It's one of the reasons under Foman, which the Supreme Court has told us is a reason that is sufficient to deny. The additional expenditure under Pasternak, that was a measure of prejudice. So when we do have that prejudice to an opposing party, that is a chance to, that is a reason to deny for a district court. And back to my, what I was saying about the precedent though, Your Honors, we do need to consider the fact that the precedent that we are setting here and fairness to defendants is fairness to all future defendants, not just those with resources, not just those who are experienced, but inexperienced litigants who might not have the resources to keep things dragging out, to defend against surprise claims in response to the summary judgment that they thought they could rely on as a tool.
Aren't plaintiffs entitled to rely on the DCO deadlines, though? If they say, I don't have to seek leave to amend until 6 months later, why should they anticipate that they need to do it sooner?
Your Honor, again, a plaintiff bears the burden of their pleadings, and you're right that they can rely on those deadlines, but specifically in this case, Ms. Jägermeyer had already amended. We might be talking about a different situation if she had never amended before, if we had never had instructions from the court, or maybe if there were additional facts that came up later, but in this case, again, she had amended before, so she bore the risk of holding 2 claims back just in case.
How many amendments is too many? Is it you get one chance to fix it, and then after that it's fair game, irrespective of what the DCO says?
Well, that would depend, Your Honor, of course, on why the reasons for amendment. For example, as we talked about, if new additional information came up, something in discovery arose that gave a plaintiff reason to assert new claims, of course that would be different. But here we are talking about a situation where she had everything she needed, and she skirted summary judgment, which is also pretty inefficient. Summary judgment is a process of efficiency, though certainly not always appropriate.
I'm glad you brought up efficiency again, because your co-counsel addressed it as well. But if this claim's held back and she still has it and summary judgment's granted, the case goes away. Let's say she never brings the claim. Could just bring another lawsuit, which is quite more inefficient than having to deal with it in the same suit?
So, Your Honor, are you asking if Ms. Jägermeyer would be able to sue later on these new claims?
On this additional claim that she never brought up to the court. In that hypothetical where it's never brought before the court at all, wouldn't she just be able to bring a new suit, which is more inefficient than what would happen if they were allowed to see the claim?
Your Honor, while Ms. Jägermeyer might decide to bring a new suit, we'd find that incredibly unlikely that a plaintiff would just bring a whole new suit rather than asserting those claims all together in the First Amendment. And I see I'm running out of time, if I may briefly conclude. For efficiency in our courts, protecting our summary judgment processes and protecting every defendant that comes to our court, we would ask that you affirm the summary judgment today. Thank you, Your Honors.
You may proceed.
Thank you. Just a couple quick points on rebuttal. First, to my co-counsel's argument, which is that the defendant's argument shackles a deponent rather, to their testimony. And just as our opposing counsel just stated in their argument, it also shackles a plaintiff to their pleading, which is that if you had a chance and now you don't take it immediately, once you get that evidence, then you forfeit your claims. And we think that's an inapplicable and inefficient rule for plaintiffs to have to plead something as soon as they have any evidence to support it. That is not what the federal rules of civil procedure say, and that goes against the tenor of the federal rules of civil procedure.
If you lost on summary judgment, could you bring a new lawsuit?
Res judicata might actually preclude that. So opposing counsel didn't state such. Actually, in Dueling versus Gristeed's Operating Corp., they actually dealt with this issue and said there might be some cases where they could, which would completely go against efficiency of handling suits in one go, because a plaintiff could simply bring new claims. Although on these claims, it seems like they're from the same operative facts, and so res judicata would preclude it. This is our only chance to plead these claims. And because defendants filed summary judgment so early in the case, we didn't have the chance to conduct discovery on them, which is exactly what the opposing counsel stated in her argument.
But at that point, wouldn't you just move for leave or motion to continue the summary judgment hearing to conduct additional discovery?
We could. The problem with that is Rule 56D requires that we state what we don't have. So we need to sort of know what we need in order to be able to have that additional time. And because we hadn't conducted discovery, because this was so far before the pleading deadlines, as Your Honor pointed out to opposing counsel, we didn't have the opportunity to simply say, look, here's what we need, here's how a continuance would work. We simply showed, look, we've got some evidence to support these claims. We just wanted to make sure that we had enough evidence to be able to bring them and meet a heightened pleading standard, especially for a difficult claim like a design defect claim. Back to the first issue, the opposing counsel also stated that it has been amended 10 times since 1937. And yet the majority of courts have always construed it broadly, and the Supreme Court hasn't found the need to change the language to disinclude form or substance, which is exactly what we're asking the court to do. Treat these as a substantive change, which they were, because Dr. Edison simply remembered differently. That's important. People make honest mistakes. Plaintiffs' lawyers sometimes make mistakes, and we shouldn't shackle them to their pleadings and to their incorrect testimony simply because the defendants want to win on summary judgment. Thank you, Your Honors.
Counsel, the court will take this under advisement. Thank you. You may be seated.
Chief, with your permission, I'll make just a few brief remarks.
Denied.
You've been waiting a long time to say that.
Yes, sir, I have.
I want to echo what Professor Berry said about thanking all of the people it takes to make this competition possible. Can't mention them all, but I did want to thank, again, all the students who put the competition on and also who served as barristers. I want to thank Faegre Drinker for sponsoring the competition. We really can't do these competitions at as high a level without support like theirs. I want to thank our judges here. I know you've spent some time here this afternoon, but it takes more time to be effective judges than just the time you spent here sitting down at the microphones and asking questions, and appreciate all the time you put in to prep it. It really adds to the experience for our students. I want to thank Professor Jessica Kincaid, who helps lead the effort to run this competition, and I especially want to thank Professor Mike Berry, who year after year, and not even year after year, twice a year, puts this competition on for our students. So I think we need to give Professor Berry a warm round of applause. I think this competition is so important for students. I think it's the light bulb moment for students when things start to come together for you and you realize, hey, you know, that Conley case in civil procedure, the Foman case, you know, it might come up again. Even appreciated, Mr. Baldry, the race judicata question that came out of that. I think you got it right. I think you got it right. And I want to thank all of you for being here to watch your classmates do this. Your presence adds a little bit of pressure, and I think that's a very good thing for them to experience. And I want to say to all four of you, you did a fantastic job, each and every one of you. I'm glad I don't have to choose the winner. I do want to say, however, that I made it to the final round of my moot court competition, and this is back in the last century, and Professor Berry, it was old even then. I don't know how long these competitions have been going on, but it was old when I was in law school. And I also want to say, I did make it to the final round of the moot court competition, and I lost. I lost the final round, and it has ruined my career. But here's the thing. I still see the lawyer who defeated me pretty regularly. She reminds me every single time that she beat me. So, but I want to say to all four of you, you did an excellent job. Just a fantastic job, and made me proud. Y'all are, it's like, wow, they are learning things, you know? And so it's very affirming. So without further ado.
Well, we all know that Dean Counselor doesn't give gratuitous compliments, so I don't think that I need to pile on, but I have to anyway. We agree it was hotly debated, and you all did a great job. And as a Baylor lawyer, you guys continue to make us proud, all of you. And it does matter when we get out there. And it was as close as it can get, and hopefully you all can do the math to figure that out because everybody did such a great job. But today's winner is the Appellees.
Okay, we turn it over to our moot court officers for announcement of awards.
All right, now for the awards portion. First, we're going to recognize the team awards, recognizing our semi-finalists, runner-up, and champions. And Allie will be handing those out. So semi-finalists, when I call your name, please come down, receive your plaque from Allie. So team number 83, that's Cole Borland and Jack Cross. other semifinalist team, Team 45, Alicia Johnson and Beth Anthony. Okay, for our runner-up team, Team 14, Kyle Zaidama and Bryce Babcock. Congratulations. And this year's champions, Team 85, we have Kelsey Crow and Caitlin Stevens.
So I'm going to be announcing our Oral Advocacy Awards. These are given for our top 10 speakers, but this year we have 14 due to ties. So when I read off for 4 through 14, these are going to be in no particular order, but when I call your name, please just stand to be recognized. So I'll start with 4 through 14, again in no particular order. So we have Kennedy Wild. We have Joe Duke. We have Cassie Crumpacker. We have Joe Gilchrist. Claire Taylor. Kat McCurdy. We have Gabriel Griffey. We have Bryce Babcock. Beth Anthony. Alicia Johnson. And Roman Martinez. Great job, guys. Okay, so now for 1 through 3, it's also a bit different. We have 2 ties for second place, so there's not actually a third place, just 2 second places, because you guys did great. So for these 3, if you could please come down to receive your plaque. And tied for second place, we have Nick Tryhall and Jordan Howell. And the number 1 speaker for this competition is Chloe Solis. All right, and if you got an award or recognition of any kind, if you could please hang around and go to the Mad Dog statue outside just for a sec so we can take pictures. Okay, thank you. That's all.
Please take brownies and cookies and everything home with you.